This hearing starts quietly, but it escalates fast. What you're about to watch is a textbook example of why self-representation can be one of the most dangerous decisions a defendant can make, especially in a felony case. The charge here isn't minor. Resisting and obstructing a police officer carries up to 2 years in prison, serious fines, and permanent consequences. And yet, the defendant walks in alone, confident, determined, and absolutely convinced he can outlawer the system. For the very first moments, the judge senses trouble. Confusion over motions, discovery requests done incorrectly, legal buzzwords thrown around without understanding. What follows is a slow, painful unraveling, not because the judge is unfair, but because the law doesn't bend for confidence without competence. You'll see repeated warnings, multiple chances to accept help, and a court bending over backwards to protect constitutional rights, even when those rights are clearly being misused. So as this unfolds, keep this question in mind. Is self-representation a right or a trap?
$1,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongly.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
okay, you haven't started out well.
Sorry. I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this.
This moment is critically important and legally airtight. The judge is doing what's known as a Ferretta inquiry, making absolutely sure the defendant understands what he's giving up by representing himself. The court explains the charge, the penalties, the risks, and most importantly, that the judge will not help him. No coaching, no guidance, no grace for mistakes. This isn't intimidation. It's protection, both for the defendant and for the record. If this case ever goes to appeal, the transcript will show crystal clear warnings were given. The judge even reminds him multiple times that an attorney can be appointed for free if he qualifies. And yet, despite all that, the defendant doubles down. I do not. At this point, the court's role changes. Sympathy steps aside, and procedure takes over. From here on out, every misstep belongs solely to the defendant.
You want to represent yourself in this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery.
This is where the wheels start coming off. The defendant keeps asking for discovery, suppression, hearings to be discontinued, but hasn't properly requested discovery in the first place. That's a fatal procedural error. You can't suppress evidence you haven't formally received. You can't halt proceedings just because you feel unprepared. The judge's frustration isn't personal, it's procedural. Courts run on steps, rules, and time. Skipping those steps doesn't make you strategic, it makes your motions dead on arrival. And notice the judge's warning. This is going to be a long, arduous process. That's judicial language for you, are hurting yourself. This is the reality of pro se defense. Knowing what you want isn't the same as knowing how to legally ask
Process
for it.
is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request
judge.
an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage,
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained. I have not. No.
And you ask
because of
them,
that,
how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I'm really, I tried to prepare my best for this. I'm really.
Okay, this was your best?
I'm
Then
not.
you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
This is one of the most brutal and honest moments in the hearing. The judge calls out what many courts see constantly. Defendants using legal-sounding language without understanding the law behind it. Saying Miranda, suppression, or competency doesn't magically trigger rights or remedies. When the judge says this doesn't make any sense. He's not being insulting, he's being precise. Courts operate on clarity. Vague arguments don't get refined, they get denied. The mention of a competency evaluation is serious. Not as an insult, but as a safeguard. If someone truly cannot understand proceedings, the court must address that. But here, the judge makes it clear. The problem isn't capacity, it's preparation. This is the moment where confidence finally collides with reality.
You do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then an attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
What's remarkable
Yes.
here is how much patience the court still shows. Despite repeated confusion, the judge grants an adjournment, explains next steps, and even facilitates discovery by allowing the prosecutor to leave contact information. That's the system still trying to function, even when one party is fighting against its structure. The judge's comment about wanting some turkey before dealing with this again adds humor, but it also reveals exhaustion. This isn't a hostile court, it's a tired one. And yet, the defendant remains resolute. No attorney, no guidance. Full self-representation. At this point, the trajectory is set. Whether he realizes it or not, every future outcome will hinge on how well he can suddenly master criminal procedure.
Defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response.
This final section brings everything into focus. The defendant wants to speak to officers on the record, but that only happens during a preliminary examination, and only if the prosecution is ready. Since officers aren't present, the prosecution requests an adjournment. Let's not delay that standard procedure. We also learned the discovery issue may not even be misconduct. It could simply be a file compatibility problem. A MacBook struggling with prosecution audio formats. That's not suppression, that's technology. This moment highlights the biggest flaw in self-representation. Interpreting every obstacle as injustice. Rather than process that, the system isn't stopping him from defending himself. It's waiting for him to do it correctly.
Unless the court has specific inquiries placed to make that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state, and I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today.
This case is a powerful lesson in courtroom reality. The judge did everything required and then some to protect the defendant's rights. He explained the charges, the risks, the penalties, and repeatedly offered legal representation. Each time, it was declined. What we're left with is a defendant fully exercising his constitutional right and fully exposed to its consequences. This case isn't about guilt or innocence yet. It's about whether confidence can replace competence in a felony courtroom, and so far, the answer is clear. Now we want to hear from you. Should courts step in more when self-representation goes this badly? Or is this the price of absolute freedom? If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.